Welcome to the next lecture of American Government 1. I'm your host, Dr. Michael Baggs, and our topic this week is federalism. Before independence, the colonies had been ruled by a mixture of royal appointees and local assemblies. These assemblies varied in their size, composition, authority, and age. The House of Burgesses in Virginia was established in 1619, House of Deputies in Massachusetts in 1634, and the Commons House of Assembly in South Carolina followed in 1670. Along with the governments of the other 10 colonies, these assemblies all share one thing in common. They are all significantly older than the Constitution of 1789. When crafting the Constitution, many of the framers cited the Baron de Montesquieu's work, The Spirit of the Laws, that advocated for the separation of powers among the government branches. Yet they conveniently omitted his claim that large republics are, quote, ruined by an internal imperfection, end quote. This observation resurfaced in the ratification debates, but Hamilton refuted this line of arguments with Montesquieu's own words describing a Confederate republic as a, quote, form of government is a convention by which several smaller states agree to become members of a larger one. And a republic of this kind, able to withstand an external force, may support itself without any internal corruptions, end quote. Thus, much like the social contract discussed in the first chapter, when the new Constitution was ratified, the state governments had to give up some of their authority to the federal government, but they did so voluntarily. Madison stated, quote, each state, in ratifying the Constitution, is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. In this relation, then, the new Constitution will, if established, be a federal and not a national constitution. End quote. When the conventions in the states ratified the new Constitution, they did so only with the belief that they were giving up some of their authority. The very first governing framework utilizing federalism was born in the United States. Federalism is defined as a system of government in which power is divided between a central government and regional governments. The framers adopted federalism as a foundational principle in its system of government for two main reasons. The first was to prevent the federal government from abusing its powers and infringing upon the rights of the people. Again, signing Montesquieu's separation of powers concept to prevent the concentration of power in a single entity, not only did the framers divide power horizontally between the three branches, quote, it also divides power vertically between the federal government and the states, end quote. Federalism was thus viewed as a prime obstacle to the advent of tyranny. The second reason, as noted earlier, state governments predated the new federal one, and they were wary of giving up too much power to the federal government. While the Constitution did provide a check on their powers, the states retained significant autonomy to govern in local matters. This was only practical, as the United States was a large geographical territory, and it would have been impossible for a federal government far removed from the locality to rule effectively. The distances between the rulers and those who would be ruled were too great to be overcome except in a federal system. Plus, the differences between the state's economies, social, and cultural characteristics made a federal one size fits all approach to governing impractical. A federal system allows for a certain amount of flexibility. Federalism in the Constitution. Even though the Constitution was written to tamp down the democratic excesses of the state legislatures, Alexander Hamilton still referred to them as the, quote, great cement of society, end quote. For the new government to succeed, the states would have to be involved, yet there needed to be clear boundaries as to where one authority begins and another ends. The Constitution grants the federal government specific powers, sometimes called enumerated or expressed powers, to govern the nation as a whole. These powers belong solely to the federal government, such as the power to declare war or the authority to coin money. The Supremacy Clause. In other parts of the Constitution, specific clauses also help to define the relationship between the federal and state governments. Article 6 of the Constitution contains the Supremacy Clause, which states, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. End quote. The framers were worried that the states would ignore the federal government as they had under the Articles of Confederation or worse, intrude upon matters best left to the national government. If the states were allowed to govern as they saw fit without regard to the rest of the Union, anarchy would eventually reign. The Supremacy Clause may be the most essential pillar of federalism in that it protected the federal government in its infancy from the states. In essence, the Supremacy Clause prevents states from enacting laws that conflict with national laws, treaties, court decisions, or the Constitution. It also provides the legal foundation for preemption of state laws when they are not valid exercises of state authority. Moreover, the Supremacy Clause serves as a warning to the states not to legislate in areas that are the sole province of the national government, such as immigration. Full Faith and Credit Clause. Article 4, Section 1 contains the Full Faith and Credit Clause, which states that, quote, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. End quote. This clause requires that state courts enforce the civil judgments of the courts of other states and to accept their public records and acts as valid. The purpose of the clause was to help unify the legal systems of the various states and to prevent conflicting judgments on the same issue in different state courts. The clause applies primarily to enforcing judicial settlements and court awards, although it does not require states to enforce the criminal laws, legislation, or administrative acts of other states. There are some exceptions to this clause. For example, the clause doesn't apply if a practice in one state goes against the strong public policy of another state. The state against the practice is not obligated to recognize it. Congress has also passed legislation to require states to give full faith and credit to certain types of laws, records, and judgments. For example, the Parental Kidnapping Prevention Act requires states to enforce child support determinations from other states. Privileges and Immunities Clause. Article 4, Section 2 states that, quote, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, end quote. Under the Privileges and Immunities Clause, states must give citizens of all other states the same privileges and immunities that they grant to their own citizens. The clause's main aim was to prevent states from discriminating against citizens of other states, ensuring that citizens have the right to travel between the states, promoting national unity, and preventing economic barriers that may arise from treating out of states citizens differently. This includes the protection of the laws, the right to engage in peaceful occupations, access to the courts, and freedom from discriminatory taxes. Because of this clause, states may not impose unreasonable residency requirements on citizens who have moved there from other states, and a state cannot give privileges only to its own residents. Interstate Compact Clause. Article 1, Section 10 states that, quote, no state shall, without the consent of Congress, enter into any agreement or compact with another state or with a foreign power, end quote. The Interstate Compact Clause purpose was threefold. First, the clause protects the national interest in that Congress's approval is required for any interstate compact. Second, it allows the states to negotiate with other states to solve problems that transcend state lines. Such compacts can be seen as treaties between the states and often establish interstate agencies to handle issues affecting an entire region. Once Congress has given its approval, the compact becomes binding on all states that sign it, and the federal courts can enforce its provisions. States may belong to multiple compacts dealing with such issues as the environment, crime, water rights, and higher education exchanges. And lastly, the clause limits a state government's efforts to engage in foreign policy. The Supreme Court has interpreted the Compact Clause to only apply to agreements that would, quote, increase of political power in the states, which may encroach upon or interfere with the just supremacy of the United States, end quote. The 10th Amendment. The 10th Amendment to the Constitution states that, quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people, end quote. The purpose of this amendment requires some explanation. The framers had initially resisted adding a Bill of Rights to the Constitution at the original convention and relented only to secure ratification. Alexander Hamilton had argued that a Bill of Rights was unnecessary and would be irrelevant to a national government that was given only delegated powers in the first place. He reiterated, quote, for why declare that things shall not be there is no power to do, end quote. So the Ninth and 10th Amendments were meant to address Hamilton's and others' concerns. The Ninth Amendment stated that, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, end quote. In other words, it warns against drawing any inferences about the scope of the people's rights from the partial listing of some of them. The 10th Amendment goes even further by warning against using a list of rights to infer powers in the national government that were not granted. The amendment's purpose was to reiterate that under this new Constitution, the government was limited by its enumerated powers. All other powers were reserved to the states or to the people. States can exercise these reserved powers as long as their decisions do not conflict with the Constitution, the supremacy and commerce clauses, or any of the other enumerated powers given to the national government. The reserved powers that each state has are divided into two broad categories: police powers and concurrent powers. The state's police powers are comprehensive and affect the lives of citizens of each state in a much more personal manner than the federal government. State governments retain the authority to regulate the health, safety, and morals of its citizens. A given state has the ability to create and enforce criminal laws, administer health and safety policies, regulate marriage and divorce laws, and to regulate individual livelihoods, such as requiring a license to practice medicine, law, and various other professions. The concurrent powers that the state possesses are essentially shared with the federal government. These included the authority to regulate commerce, such as in chartering banks or licensing requirements for certain professions, regulating labor conditions in the state, and last but not least, the ability to levy taxes. States can and often do tax the same items that the federal government taxes, like income, alcohol, and gasoline. However, states cannot use their concurrent powers to unduly burden commerce among the states, interfere with the function of the national government, or complicate the operation of a national law. The framers divided government powers to give states strong authority over issues that are close to home, and the national government powers to protect the nation as a whole. They also gave some powers to both the national government and the states, which occasionally creates conflict between the national and state action. When Congress is either silent or unclear about the proper balance between national and state powers, the Supreme Court must often resolve the issue. In general, the lack of a national law is viewed as permission for state action. The Supreme Court on Federalism. The Supreme Court's first effort to define federalism occurred in 1819 with the McCulloch versus Maryland court case. The controversy centered on Congress's authority to establish the Bank of the United States. While many states questioned the constitutionality of such an action, Maryland actively opposed any national bank within its jurisdiction and enacted legislation that levied a $15,000 tax on any bank not incorporated in the state. The cashier of the Bank of the United States in Maryland, James William McCulloch, refused to pay on the grounds that a state could not tax an instrument of the national government. Maryland sued in federal court to collect the taxes, and the case eventually ended up before the Supreme Court. Maryland was represented before the court by some of the country's most distinguished lawyers, including Luther Martin, who'd been a delegate at the Constitutional Convention. Martin's legal defense of Maryland was based on two arguments. The first was that the Constitution did not expressly delegate to the national government the power to create a bank. Martin claimed that the necessary and proper clause only gave Congress the power to choose those means and to pass those laws absolutely essential to the execution of its expressly granted powers. Because a bank is not absolutely necessary to the exercise of its delegated powers, Martin argued, Congress had no authority to establish it. The national government was also represented by some very distinguished lawyers, including one of the country's greatest orators, Daniel Webster. Webster, in his argument before the court, conceded that the power to create a bank was not one of the expressed powers of the national government. However, the power to pass laws necessary and proper to carry out Congress's expressed powers is specifically delegated to Congress. Webster also argued that the Constitution leaves no room for doubt as to which level of government has the final authority when there is a conflict between a state and national law. According to the Supremacy Clause, Webster argued, the national law must be obeyed. Speaking for a unanimous court, Chief Justice John Marshall rejected every one of Maryland's legal arguments. Because the Constitution delegated to Congress the authority to coin money and to regulate commerce, establishing a national bank was well within congressional authority. Marshall, in his decision, then outlined the concept of national supremacy. No state, he said, can use its taxing powers to tax a national instrument. Relying on the Supremacy Clause, he wrote that, quote, the power to tax involves the power to destroy. If the right of the states to tax the means employed by the general government be conceded, the declaration that the Constitution and the laws made in pursuance thereof shall be the supreme law of the land is empty and unmeaning declamation. End quote. The second important case that the Supreme Court decided that affected the relationship between the federal and state governments was Gibbon versus Ogden in 1824. The case involved a New York state license that gave Aaron Ogden the exclusive right to operate steamboats between New York and New Jersey. Using the license, Ogden asked the New York state courts to stop Thomas Gibbons from running a competing ferry. Gibbons countered that his boats were licensed under a 1793 Act of Congress giving him permission to operate in the waterways. Because Ogden's license was granted by the state of New York and the case was argued in that state's courts, the New York courts sided with Ogden. Using a concurrent power argument, the New York State Court stated that just as the national government and states both have the power to tax, they both also have the power to regulate commerce. Gibbons appealed to the Supreme Court to answer a simple question. Which government has the ultimate power to regulate interstate commerce? The Supreme Court gave an equally simple answer, the national government. The Commerce Clause of the Constitution states that Congress has the power to, quote, regulate commerce with foreign nations and among the several states and with the Indian tribes, end quote. By ruling that states may not discriminate against each other's trade or commerce, Gibbons versus Ogden was immediately heralded for promoting a national economy. For 200 years, the Supreme Court's definition of commerce as intercourse among the states provided the basis for national regulation of an expanding range of economic activities. The modern Commerce Clause. The two Supreme Court rulings above provided the foundation to expand federal power at the expense of the states through its interpretation of the Commerce Clause. Yet for a considerable time, the courts resisted most congressional attempts to use it to expand its power. The courts began to reinterpret its prior decisions on the Commerce Clause during the Great Depression due to pressure from President Roosevelt and Congress. The case that broke the dam was Wickard versus Filburn in 1942. Congress had passed a law in 1938 that set quotas for wheat production to try to stabilize prices. Filburn was a small farmer in Ohio who had produced more than his allotted quota of wheat 2 years in a row and was fined. In his appeal of the fine, Filburn argued that the excess wheat was unrelated to commerce since he grew it for his own use and it never entered the market. Thus, it, quote, had no effect on interstate commerce, end quote. The court reasoned that had he not grown the extra wheat, he would have had to purchase wheat. Therefore, he was indirectly affecting interstate commerce. But the real important aspect of the decision was that the Supreme Court now, quote, reasoned that Congress could regulate activity within a single state under the Commerce Clause. Even if each individual activity had a trivial effect on interstate commerce, as long as the interstate activity viewed in the aggregate would have a substantial effect on interstate commerce. End quote. Before this decision, the courts generally tried to decide whether action under review was a local, that is, confined to one state, or, quote, whether its effects were direct or indirect, end quote. Due to the precedent set by the Wicker decision, the door was wide open to allow Congress to regulate anything that can be even remotely construed as commerce among the states. In 1990, Congress passed the Gun Free School Zones Act, which made it a crime to possess or discharge a firearm in a school zone. Congress cited its powers under the Commerce Clause, specifically that the possession of a firearm in a local school zone substantially affected interstate commerce. How does this affect interstate commerce? The governance rationale argued before the court stated that violent crime raises insurance costs, and those costs are spread throughout the whole population. Violent crime also reduces the willingness of individuals to travel to high crime areas within the country. And finally, crime threatens the learning environment, thereby reducing national productivity. While all of these might be true, the relevant question is whether Congress had constitutional authority to pass the Gun Free School Zones Act. In the court case U.S. versus Lopez, 1995, a high school student in San Antonio, Texas, was charged and convicted for violating this law, and challenged the legality of whether Congress had any authority to enforce the act. The U.S. Supreme Court ruled it didn't, stating in its opinion, quote, if we were to accept the government's arguments, we are hard pressed to posit any activity by an individual that Congress is without power to regulate, end quote. In other words, the hours children spend studying, the amount of rest they get, and what they eat all have something to do with learning. Congress could easily manufacture a case for the regulation of these activities based on its interpretation of the Commerce Clause. This case marks one of the few times since the Wicker decision that the court has checked Congress's authority under this clause in over half a century. Federalism in practice. Federalism to this day remains a contested system of power sharing. The federal government and states continue to argue about the appropriate exercises of power at both levels. However, the system of federalism does not prevent action by either, as governments at all levels cooperate and make decisions every day without the slightest bit of controversy. Nevertheless, debates between the states and the federal government about the balance of power will continue far into the future. What drives these debates are the historical practices of each entity and how they have shifted over time. For over a century and a half since the Constitution was ratified, there was a strict separation of powers between the national and state governments. This separation of powers has been termed dual federalism. Some call it the traditional system. Dual federalism posits that the federal and state governments each possess power over their citizens, but that power is limited to separate and distinct spheres of authority, and each government is neither subordinate to nor liable to be deprived of its authority by the other. The concept of dual federalism is consistent with the Constitution's various clauses that dealt with the relationship between the federal government and the states, that is, the Commerce Clause, the Necessary and Proper Clause, Supremacy Clause, and the 10th Amendment. However, some claim that the interpretations of the above clauses need to be quite narrow for any constitutional justification for dual federalism. Nevertheless, even with the expansion of federal authority to win the Civil War, after the Reconstruction period, it still did not intrude upon the domestic affairs of the states. Each government had its own responsibilities and reigned supreme within its own constitutional realm. Most of the day to day governing was done by the states, while the federal government dealt primarily with commerce, economic development, and foreign affairs. The Great Depression in the 1930s marked the end of dual federalism and opened the door to increased federal government actions in the states to respond to the economic crisis. When the Depression first hit in 1929, the current president, Herbert Hoover, believed that it was the state and local government's primary responsibility to deal with the effects of the economic crisis. States had limited resources to deal with poverty and unemployment that was rampant, and there were no federal welfare programs to assist them. At the end of Hoover's term in 1932, unemployment rate was somewhere around 25% of the workforce. The American people demanded that the federal government act. In that year, they handedly elected Franklin Roosevelt, who had pledged to address the nation's economic problems head on. FDR's New Deal attempted to alleviate the effects of the Great Depression through national programs that were termed grants in aid. Essentially, grants in aid are when Congress gives money to state and local governments, but this money comes with strings attached, in that the federal government determines exactly how these funds must be spent. This includes what is known as a categorical grants, which accounts for about two-thirds of this type of spending. Categorical grants are funds to the states that can be only used for specific benefits such as low income housing, Medicaid, or unemployment insurance. The growth of categorical grants helped bring about the era of cooperative federalism. This is a system in which both levels of government work together to solve policy problems. Cooperative federalism is designed to encourage states and localities to pursue nationally defined goals. Political scientist Morton Grodsons used a cake analogy to describe this system. Dual federalism is depicted as a layer cake, where the responsibilities of the national government and state governments are clearly separated, while cooperative federalism is depicted as a marble cake, where national policies, state policies, and local policies overlap in many areas. However, this intergovernmental cooperation and sharing make it difficult to distinguish where the responsibilities of the national government end and where the responsibilities of state and local governments begin. President Nixon pushed for more block grants in the 1970s as part of his new federalism approach, and Congress responded with a new form of assistance to state and local governments through general revenue sharing, which merely sent money back to the states with no strings attached. But after Nixon's resignation, there was a move toward what was termed regulated federalism, where Congress imposed legislation on states and localities requiring them to meet national standards. With the increased usage of grants and aid, the national government often demanded the states meet higher standards, and they also imposed stricter uses for the funds that Congress had provided. In some instances, these national standards required the federal government to take over areas of regulation. This preemption occurred when state or local actions did not agree with national requirements. Another issue was unfunded mandates, which are legislation and rules forcing states to spend their own money to comply with federal law. The problem with this is that nearly all states have legal or constitutional provisions that require balanced budgets. So, throughout the 1970s and 1980s, unfunded mandates created budgetary problems for state governments. Congress subsequently tried to limit unfunded mandates in the 1990s, but they continued to add budgetary issues for the states to deal with. In the 1990s, there was a revival of interest in the 10th Amendment because many conservatives argued that a strong federal government encroached upon individual liberties. Two Supreme Court cases reinforced this perception and ruled that Congress had exceeded its power. In U.S. versus Lopez, the court struck down a federal law that barred handguns near schools. And in Prince versus the U.S. in 1997, the court declared unconstitutional a provision of the Brady Handgun Violence Prevention Act that required states and local officials to conduct background checks on handgun purchases. The Prince decision also established that the federal government cannot force state officials to implement federal laws. Later, federal efforts to compel states to enforce immigration law had been ruled unconstitutional because it violates constitutional restrictions on federal commandeering of state governments. Justice Sandra Day O'Connor wrote that, quote, the federal government may not compel the states to enact or administer a federal regulatory program, end quote. This has come to be called anti commandeering doctrine, and it means that while states and localities can't actively impede federal enforcement of laws and rules created in Washington, they don't have to expend a single dime or drop of sweat to assist the federal government. This doctrine has been invoked by some to establish sanctuary cities that don't cooperate with federal immigration authorities or that don't help enforce federal gun laws. Other efforts to limit the power of the federal government include devolution, or the transferring of responsibility for policy from the federal government to state or local governments. Also, proponents of greater state power have looked to block grants, which are federal grants in aid that allow states considerable discretion how funds are spent. Pros and cons of federalism. Federalism offers five significant advantages for creating impact and on solving difficult problems at all levels of government. Federalism protects the nation against tyranny. When one political party loses control of the national government, it is still likely to hold office in a number of states and can continue to challenge the party in power at the national level. The framers saw the diffusion of power as a check against factions. They believed that federalism would make it more difficult for any one ideological group to impose its will on the nation as a whole. Federalism allows unity without uniformity. The national government cannot solve every issue that divides the states. Instead, issues are debated at every level of government. Information about state action spreads quickly from government to government, especially during periods when the national government is relatively slow to respond to pressing issues. Federalism encourages innovation. States can be the laboratories of democracy. If they adopt programs that fail, the negative effects are limited. If programs succeed, they can be adopted by other states and by the national government. Georgia, for example, was the first state to permit 18-year-olds to vote. Wisconsin was a leader in requiring welfare recipients to work. And Massachusetts created one of the first state programs to provide health insurance to all its citizens. Federalism produces new leaders. Federalism allows state and local leaders to gain experience before moving to the national stage. Presidents Jimmy Carter, Ronald Reagan, Bill Clinton, and George W. Bush previously served as governors of the respective states of Georgia, California, Arkansas, and Texas. All told, 20 of the nation's 45 presidents served as governor at some point before winning the presidency. Federalism promotes government by the people. By providing numerous arenas for decision making, federalism provides many opportunities for Americans to participate in the process of government and helps keep government closer to the people. Every day, thousands of U.S. adults serve on city councils, school boards, neighborhood associations, and planning commissions. Federalism also builds on the public's greater trust in government at the state and local levels. The closer the specific level of government is to the people, the more citizens trust the government. Even though federalism offers a number of advantages in creating impacts, it also creates at least four potential barriers as citizens seek answers to their problems. Federalism confuses citizens. Just as federalism encourages cooperation between federal, state, and local governments, it can confuse citizens about which government to ask for help. Where do they go to ask about better schools? Whom do they ask for help in getting health insurance? What kind of job training is available from the federal, state, and or local government? The answers are often confusing and thereby undermining the sense that federalism works for the citizens. Just as federalism confuses citizens, it also weakens accountability. In times of crisis or scandals, it is important for the public to be able to attribute blame. Blame attribution occurs when individuals, political parties, media, or the public assign responsibility for policy failures, crises, or unpopular decisions. It plays a crucial role in shaping public opinion, influencing elections, and determining political accountability. But more importantly, blame attribution influences the public's trust in the government. Trust erosion makes it harder for the government to pass policies, rally support, or even recover from mistakes. If the public cannot attribute blame for a failure on either a local, state, or federal government entity, then the whole system will suffer a loss of confidence from the entire population. Federalism creates inequality. The freedoms that stimulate innovation across governments can create inequality in states that set lower standards. Where national laws do not exist, it is tempting for each state to try to undercut another state's regulations to gain a competitive advantage in such areas as attracting new industry, regulating environmental concerns, or setting basic eligibility standards for welfare or health benefits. However, it is the race to the bottom that is the most concerning. Many observers maintain that state and local governments should not be in charge of redistributive programs. These programs are designed to transfer income through taxing and spending with the goal of benefiting the poor. Because state and local governments have to compete with one another for residents and businesses, they lack any incentive to spend money on needy people. If one state cuts assistance, neighboring states will make similar or deeper cuts to reduce spending and to discourage the poor from moving to their states. And last but not least, it is not clear if state bureaucracies are any more efficient or capable than national agencies. There are multiple examples in the state governments of wasteful spending, general incompetence, and sometimes outright fraud. The end. References